what are the aims of international criminal justice, and are this type of tribunal in particular and the whole project of international criminal justice something which has actually a positive or negative legacy, something which fulfills or doesn't fulfill the objective it is given. International law has been, for the last few decades, mostly relying on criminal avenues to deal with wartime violence, and they basically are presuming that this is the most appropriate approach, rather than actually assessing what are not only benefits but also the demerits of this approach. And as a result of that, you have alternative means of conflict management which are much more restorative, which are put on the side and disregarded as not being considered sufficient for the perspective of fight against impunity. Now, there is serious need to test this uncritical assumption, because international criminal justice, to a large extent, doesn't fulfill any of the aims it is giving to itself. So my presentation will deal with this question first, trying to figure what are actually the aims of this type of institution. So what is the aim of international criminal tribunals? And then all the ICTY in particular has been delivering or not delivering at every of those levels. So the first thing for assessing the success of international criminal justice at this level is to define what are its aims. Now, from a legal perspective, this is finally a legal paper, and I'm a lawyer, not a political theorist or a political scientist. We are going back to the text, so to the legal norm, which is in this case the Security Council Resolution 827, which is the resolution which created the ICTY. So what the resolution says is that the tribunal has for sole purpose the prosecution of people, of persons responsible for serious violation of international humanitarian law committed in the territory of the former Yugoslavia. So this is the first norm. Now, from perspective, again, from interpretation of international law, you have the text, and then you have the context, which in this case is the adoption of this text in the frame of Chapter 7 and Article 24 of the UN Charter of Powers. So powers which have to do basically with maintenance of international peace and security. So apart from the textual objective aim, which is inscribed in the resolution itself, there is a need to look from a teleological perspective at the function of the tribunal in order to first, at the time when it was created, restoring the peace, since it was still ongoing armed conflict, and secondly, after the end of the hostilities, maintenance of peace and its consolidation. So the idea of reconciliation would go into that, the idea of consolidated the peace and the security. Problem being in practice, of course, that instead of having those two things going hand in hand and ending up having peace through justice, you often have issues of, you have either peace or justice, so of peace versus justice. So the problem of the ICTY is, what are they going to choose? What are they going to do? So the ICTY itself has been trying to clarify its objective, and it considered its main mandate originally like threefold. So they were saying they were supposed to do justice in the retributive sense of the term. Then they were supposed to deter further crimes. And then they were supposed to, at the same time, contribute to the restoration and maintenance of peace. So they took the two elements, and on the justice side, they didn't only take the retributive aspect, but also the deterrent aspect. In the evolution of its mandate, in the evolution of its work, it also added the idea of rendering justice to the victims of the crime. So this was an additional element. In the judgment itself, you have, varying from one judgment to another, some judgment determining what is the purpose, not of the whole ICTY's work or of the whole ICL project, but of sentencing in particular. And then you have a list which goes in all the directions. So you have anything which has ever been taken as an aim by any kind of criminological studies going there. And sometimes you have one part of the list, sometimes you have another. You have things which are called, I mean, retribution is sometimes just desert with no reference to what is just and where you take it there. So the deterrence sometimes is general, sometimes is specific, sometimes you have some symbolic vision of criminology in it. You have all kind of things. And you don't have a single judgment which have that listed or truly explained. You have no reliance on any criminological or legal theory justification for any of that. So you end up with a list of very, very messy, unclassified, and irreconcilable aims. So the court is, according to some of its judgment, supposed to do everything. And you have, on the other hand, that original mandate coming from Security Council, which already has quite a few elements. At least, going from that, they should be taking into account for the classification of the aim to look at and not at this list of 20 different things which are clashing, taking into account the fact that the court recognizes itself that deterrence actually, even though if it says put it as its original mandate, is something which is not going to work at the level of sentencing in front of International Criminal Tribunal. And they recognize the same for social defense and for rehabilitation. So they are basically saying the type of exercise of justice we are doing is not going to help. It is not going to have a deterrent effect. It is not going to have a social defense effect, and it's not going to have a rehabilitative effect. So you have judgment basically already saying this is actually, even though we might have thought it's the goal, this is not going to be possible with this type of trial. And they also recognize the fact that you have clashes between the different aims, self-appointed aim. So the idea would be to go back then to seeing what is the idea of delivering justice, seeing it from the classical perspective of deontic justice, and seeing it from perspective which also includes in it the idea of respect for human rights. So not end up with justice as it was made in the Nuremberg sense of the term, but justice which is also including all the procedural guarantees. So justice including defense rights and the rights of other individual parties to the trial. Then the need to actually respect the rights and interests of the victims and redress and give redress to victims. And finally, the idea of securization of peace and of reconciliation. Now the problem is, if you look at those three aspects one after the other, and you see in detail for the different provision what it leads to, you end up seeing that there are actually much more problems than improvement at every single of those levels. Now, one of the problems which led this UI itself to realize that deterrence was not going to be forwarded by the type of process that they were involved in, or social defense or rehabilitation, but which is also one of the reasons why they will have actually a lot of difficulties into even delivering justice from a retributivist perspective, is actually the fact that that type of criminality is not ordinary criminality. The fact that you cannot have just rules applied which are ordinary rules coming from either one national judicial system or a combination of both, because process is mostly adversarial but with some inquisitorial elements. So it's a mix of a lot of different things which don't also hold together very well. But it's a transplantation of different national rules more or less harmonized, but for ordinary crimes. Now, the thing is, these kind of ordinary crimes are not at all the kind of crimes which is committed in times of armed conflict. So you have the problem, the first problem of that, which is the fact that any of those modern or contemporary legal system requires some elements of mens rea for criminal law. So you don't have just civil liability, which is based on you committing an act, but you need to want to commit it. Now, this element of mens rea is implying that you acted from your own perspective with your own free will. It means that you should actually have it yourself, the free will. Because of that, you have in most criminal law theories the idea that you have causes of exoneration in case of duress. So if people are forced, if there is something against their will, then the mens rea element is not there, and then the person is going to be acquitted. Now, the problem with here is that the type of crimes which is committed in times of civil war is often committed under duress, and it's often committed at systemic level. So you will have a really serious problem about proving this element of mens rea and doing it honestly and not just assuming it. Another problem there is that the idea of ordinary criminal law is that it's aimed at targeting transgression, targeting the fact that the person is actually some way asocialized or some way in opposition with the rest of the group, while with war criminality, a lot of the things is actually due to either patriotic reasons or obedience reasons of the fact of being pressured between different groups. So the type of psychological or criminological element when there is before the commission of the crime is not at all what is in a classical criminal law. The idea that you are basically punishing transgression as a moral wrong works as long as you have an idea of a system which is more or less recognized with an idea of what is right and wrong. Now, the problem is when you end up to be in a situation like war or totalitarianism, where the person doesn't actually have their own free will anymore on determining what is the right and the wrong and on applying for themselves the right and the wrong, but where they are in a system where either there is duress put on them or there is incentive into doing not even necessarily materialistic or instrumentalist incentive, but where there is more and more of a dehumanization of the other person, division of the whole morality depending on the different parties, and where you have pressures and authority pressures going in that direction, the person ends up at some point not considering the thing as a wrong anymore, but either as something neutral or something acceptable, or even sometimes as something which is commendable and better for them to do. So you would have the person committing the crime as basically thinking it's not even that they didn't do something wrong, but they did what is expected from them, from society, or sometimes even what is something they start considering good in itself, independent of the expectation of the society. So from international criminological perspective, you end up that those crimes actually cannot really be considered as individual crimes per se, but most are collective crimes or systematic crimes. And for sure, they are manifestation of collective violence, and they are much more generated by the context itself, which is basically a war, than they are by something which is wrong in the individual as such per se. The same individual put in a normal peacetime circumstance is not somebody who is going to go around the streets of Novi Sad with Kalashnikov and just randomly kill people. It is something which is really very much related to the situation. And this type of criminality means that these people, once they are either, okay, if they are acquitted anyway, they're not criminal, but if they were punished and after their sentence liberated, are people we won't have the same issues of deterrence, social defense, and so on, in the sense that they would perfectly reinsert in society, because the issue is not one of transgressing against social norms, but on the contrary, tied to the situation. Because of that, the ICTY has been actually taking a midway, which is not to say these people don't have mens rea because the situation is like that, but also not to say we just punish the person who did the act at the lower level because they are actually the one who committed the act, but we also want to do the people behind it, planned it. And so what they have basically done is you have either the element that you committed, or you have the element that you have planned it, or you have actually neither nor, but you were part of that whole system. So they actually take note of the fact that it's not an individual crime being committed, but that it is indeed a systemic crime. But then they go from that to, therefore we can basically end up punishing anybody who was part of the system at one level or another, and who was caught here one way or another. And the type of indictment policies and the type of evolution of prosecutorial approach over the year is actually very discriminatory, or rather, it's not necessarily discriminatory with plan, but at least it is not consistent. So there is not a set of really consistent theoretical or practical pattern. It has evolved with different interests of the tribunal, different time of its history. So you end up having the feeling that you have a few scapegoat people taken originally on whom they could put their hands on, and then later on trying to target people on the maxima. Sorry. Okay, I'll need to be very fast. So there is the idea that they have scapegoated people, and then what they have been doing is basically expanding all kind of possible mechanism, so that you won't have any respect of this mens rea principle. You won't have any respect of all the basic rights of defense. So you have all the basic rights of defense which have been cut down to allow for more conviction. So you have the idea that you have this fight against impunity, which is growing and growing and growing, and giving a justification for all kind of classical defense rights to be progressively eaten up. Then you have the problem that this is creating a hybrid regime, where you had also the element of reconciliation. I'm sorry, I completely lost track of the time, so I'm out of that. But the idea that they organize a whole system with the idea of protecting the right of the victims and the witnesses, but in practice it never worked. So there is no compensation at all being given in front of the ICTY for victims, and both victims and witnesses have been further victimized by the system and their life put at risk. Then there is the point of actually trying to reach reconciliation in the society. And there you have the problem that actually there is a very selective application on which case pass and which case don't pass. And the problem is, if you see that everything is system criminality rather than individual criminality, the first thing you need to look at is actually the group, not only as group, but who are the people who created that whole phenomenon. So there you would have to put responsibility more on states and on group of individuals like they've been doing under it. And mostly you would have to look at what are the actions of the state who created the conflict, rather than just the actions of the state which are inside the conflict. And that would, of course, require looking at what the major powers have been doing, or were they responsible into first, what they did at the moment when there was tension raising, were they responsible or not for what happened, for the war in itself. Then you have powers which are breaking down, you embark on weapons. What is the responsibility for that? Then the management of the conflict on the place. Then the top of it being the NATO bombing. But you have it all over the process, from the breakup of Yugoslavia to the NATO bombing, at every level, a lot of responsibility for what happened directly on the ground, which actually has to be imputed at actors which are not at all based inside the region. But if you take this ICL type of mechanism, you can ignore their responsibility. You can say, no, it's individuals, and we are limiting it to, well, originally just the person who fired the gun, and then the person who fired the gun plus, well, is president or prime minister in general in chief. But we're not going to look at what is being done in Brussels, say, coming from Brussels or any other capital in the world. So you have this problem, and this means that the people will not want to see this as a process where you have individuals which are going to be tried really for the crimes. So what you were saying about in Nuremberg, they were actually quite happy to receive, Germany was at the time happy to receive Nuremberg and was considered as something legitimate because they could say, yeah, this is the responsibility of Nazi and not of the rest. Yes. The problem is that there is here a feeling which is not the same from what comes from the different polls, which is that it is not perceived as something acceptable because it is also tied to the fact that the tribunal itself is being used as a way from external power to say, okay, these people are bad, and these people are, and then the whole press going with it, this is savagery and all that, and then negating the fact that there are external elements, external factors, and external actors which will never pass in front of any of those courts and who are responsible for it. So you have a problem at that level, that this doesn't then bring this kind of process which would allow in reconciliation. I was, after that, supposed to work on alternative to this, but I think I will keep that for the paper because I'm running too much out of time. But thank you very much.
Okay, thank you, Axelle.